In this video, I'm going to explain how to obtain power of attorney in Oregon. I'll cover the different types of power of attorney, the essential requirements, and the benefits of using statutory forms. So by the end of this video, you'll be able to confidently create your very own power of attorney. And by the way, if you feel like you need help creating power of attorney, then I recommend contacting people from lawdepot.com because they are professionals and they will be able to help you. I'm going to leave a link to their website down in the description of this video. And with that in mind, let's get right into it. Understanding power of attorney. What is a power of attorney? A power of attorney is a legal document that allows a trusted individual to handle specific financial matters on your behalf. These matters may include depositing checks, filing taxes, or making decisions related to your real estate property. Types of power of attorneys in Oregon. Oregon recognizes several types of power of attorneys, with the most common ones in estate planning being financial power of attorney. This type allows someone to manage your financial and business matters. Power of attorney for healthcare. In Oregon, this document is combined with a living will into a single document called an advance directive. It grants someone the authority to make medical decisions on your behalf. Both of these power of attorneys are typically durable, meaning they remain effective even if you become incapacitated, making them vital for unforeseen circumstances. Legal requirements for a financial power of attorney in Oregon. To create a valid financial power of attorney in Oregon, certain legal requirements must be met. Mental capacity for creating a power of attorney. The individual creating the power of attorney must be of sound mind. While the exact criteria for mental capacity may vary, generally, individuals creating power of attorney should be able to understand their actions. If you have doubts about meeting this requirement, consulting an estate planning attorney is advisable. Notarization requirement. While Oregon's power of attorney laws are silent on notarization, it is strongly recommended to sign your power of attorney in the presence of a notary public. Many financial institutions require notarization to authenticate the documents. Steps to obtain a financial power of attorney in Oregon. Here's a straightforward guide to creating a durable financial power of attorney that is valid in Oregon. Step number 1. Create the power of attorney using a form, software, or an attorney. Numerous private companies offer forms or templates that you can use to create your power of attorney. For a user-friendly experience, consider using lawdepot.com, which guides you through creating a valid state-specific POA and estate plan. Alternatively, consult an Oregon lawyer to create a power of attorney, especially if you intend to include it as a part of a comprehensive estate plan. Regardless of your chosen method, the power of attorney creation process typically involves granting your agent specific powers. You can select these powers from a list, such as those related to real estate transactions, banking, financial transactions, retirement plans, securities transactions, business operations, government benefits, tax matters, personal and family maintenance, and more. In Oregon, your power of attorney is durable, effective even after your incapacitation by default. Step number 2. Sign the power of attorney in the presence of a notary public. As mentioned earlier, it is advisable to have your power of attorney notarized. Step number 3. Store the original power of attorney in a safe place. Once the power of attorney is completed, store the original in a secure location that your loved ones can easily access. Ensure they know where to find it, as your attorney in fact may need the original in case you become incapacitated. Step number 4. Give a copy to your agent or attorney in fact. Provide a copy of the power of attorney to your appointed agent, ensuring they are familiar with its contents. Step number 5. File a copy with the recorder's office. If you have granted your agent the authority to conduct real property transactions, file a copy of your POA in the land records office, referred to as the recorder's office, in the county or counties where you own real estate. This will allow the recorder's office to recognize your agent's authority if your agent ever needs to sell, mortgage, or transfer real estate for you. Step number 6. Consider giving a copy to financial institutions. Share copies of your durable financial power of attorney with banks and other institutions where your agent might need to carry out transactions. This step can streamline the process, as some banks have specific requirements for accepting power of attorneys. Naming an agent in Oregon. From a legal perspective, you can name any competent adult as your agent. However, practical considerations such as trustworthiness and geographical proximity should influence your choice. While you can appoint co-agents who can act simultaneously, it is usually advisable to have a single agent to minimize potential conflicts. Nevertheless, designating a successor agent, an alternate who assumes the role if your primary agent is unavailable, is always a prudent move, as it establishes a backup plan. When does my durable financial power of attorney take effect? By default, your financial power of attorney in Oregon takes effect immediately upon creation, unless you specify otherwise. While you can set conditions that must be met for activation, this springing power of attorney is typically not recommended due to its potential complexities. When does my financial power of attorney end? Several scenarios can lead to the termination of your financial power of attorney. Revocation. You can revoke the power of attorney at any time, provided you are mentally competent. No available agents. If there is no agent or successor available to act on your behalf. Court invalidation. Although rare, a court may invalidate your document if it determines that you lacked mental capacity when signing it, or that you were a victim or fraud or undue influence. And don't forget that if you feel like you need help creating power of attorney, then I recommend contacting people from lawdepot.com because they are professionals and they will be able to help you. I'm going to leave a link to their website down in the description of this video for your convenience. I hope this video was helpful. Thank you so much for watching. Subscribe.